If you've just joined us, you're watching Newslink on DSU channel 403. Now, public interest organisation Sakeliga has started contempt of court proceedings against Cooperative and Traditional Affairs Minister Dlamini Zuma. It's alleged she's failed to provide the records she relied on to declare a state of disaster and impose lockdown regulations in response to the COVID-19 pandemic. You remember the minister was at the forefront of government's attempts to limit the effects of COVID-19. For more on this, I'm now joined by Sakeliga CEO Piet. Mr. Roux, good morning and thank you very much for your time. So this particular matter relates to the December order to release the records of the decisions that led to the issuing of several regulations during the hard lockdown. Just for the benefit of those who might not necessarily be familiar with the court case, just give us a brief background.
State officials are obligated under the Promotion of Access to Information Act to provide us records for their decisions. And Dr. Dlamini Zuma made important decisions, several, not only in initiating the original state of disaster, imposing the various lockdowns, but every subsequent renewal and every regulation from banning roast chicken to not going to the beach and costing eventually 2 million people their jobs and so on. So very intense decisions were made. And in December of 2020, we initiated a Promotion of Access to Information Act request where we asked Dr. Dlamini Zuma to provide us with the records for her decision. That is the reasons she relied on, the reasons she made every decision she did regarding the state of disaster. And she refused that information. We appealed the internal appeal process of the department. They again refused the information, claiming that they were cabinet privilege and so on. And then we went to court because you cannot claim cabinet privilege. And eventually, in November last year, the court found that she has to give us this information. And we persist with this, we insist on getting that information.
Interestingly enough, though, when you speak of the privilege that is attached to cabinet, this was her posture or her position. She maintained this. But interestingly, there were no opposing papers filed.
Yes, it's curious. She did not file opposing papers in the end. And so she did not, it seems she did not want to be tied down to that under oath in court. It's unclear why she did not file opposing papers, but it's clear anyway, and our legal arguments were ready. There's no cabinet privilege to her decisions. She acted in her capacity as a state official under law. And it's quite sure we don't need access to all cabinet deliberations. We need her reasons for making the decisions she did. So that's an untenable position. And she has, since the court order in November last year now, repeatedly failed to provide the information. And so we are escalating this to a contempt of court case now.
Was there no documentation furnished to you whatsoever?
Quite a bit was furnished. Digitally, several thousand pieces of paper or pages, and physically around 3,800 pages last week was delivered to our attorneys by the state attorney who acts for Dr. Dlamini Zuma. These papers are irrelevant, though, or insofar as they are relevant, they were already in the public domain, and they certainly do not correspond with what she refused to give us. So where are the intergovernmental correspondence? Where are the draft regulations and subsequent changes? Where are her decisions for each of the lockdown extensions, the minutes of the meetings? These were not forthcoming. So either she, the court order is very clear. She can be under no misunderstanding with the aid of her legal advisors on what she is obligated to provide. She could argue that some of that does not exist, while we are confident that a lot of it does exist. And insofar as something doesn't exist, she needs to say that it doesn't exist. Or insofar as she was instructed by somebody else to do something against her will, possibly she has to say that. Point is, we need the reasons, and we will insist on this. And what she has provided does not comply with the court order.
So where to from here? We understand you've instructed your attorneys to now apply, or you want an application for contempt of court.
Yes, it's important to hold state officials to account. Civil society organizations should balance state power. And if we let state officials who make such extravagant decisions as were made by Dr. Dlamini Zuma over the course of more than 2 years, impacting millions of lives, costing people their jobs and the food they want to put on their kids' table, If we allow them to get away with doing things like that without giving us reasons, we set a very bad precedent. So that's one reason we continue with this application. And the second is, even now there's some new fear-mongering going on about so-called, new variants and so on.
Yes.
And people speak about masks, and the command council gets together again. We don't want to repeat of the mistakes of the past 2 years. And so it's important to us to hold state officials to account and to balance state power. And that's why we're escalating this to a contempt of court application, which is a separate application. And we will now try to prove to the court that Dr. Dlamini Zuma holds the court in contempt. That is, she ignores willfully their orders, which we are confident we will be able to do. And we've asked the state attorney to give us reasons for why we should not proceed with such an application.
All right, Mr. Roux, thank you very much for your time this morning. That's Sakeliga CEO Piet.